So I'm assuming people are out there, and thank you for coming. Um, so this is our first presentation in the victim rights attorney track. So I'm really excited about that. My name is Andrea Rufo, although I just go by Anne. I am the director of the Crime Victim Rights Project at Legal Action. Our project is a joint project with Judicare. Patrick also works on the project and was going to do the presentation with me, but he is actually in court right now. He had a hearing come up that he didn't expect. So I'm going to be flying solo. He's going to be, I think, particularly sad because I know that we both have a great love for Star Wars, The Mandalorian, and particular Baby Yoda. So just a couple quick things. I really did pick this theme because I like having themes. I think it makes it more fun. But it occurred to me that it might be a little aggressive, be like, this is the way. So I apologize for that. I'm not trying to be aggressive. Also, I don't, because Patrick's not here, I am gonna have trouble reading questions in the chat. And I'm gonna try, but most likely what's gonna happen is that I'm gonna end up like saving them to the end, or I'm gonna review them after and on the forum, the community forum, respond to them. So let me go ahead and kind of get started. So the first place to really start is what is the reason that we even want to protect victims' privacy? And there are several reasons. The most obvious is it's protected by law. Violations of privacy can violate the dignity and respect of a victim. It could compromise a victim's safety. It could compromise victims' care or treatment, and that's particularly medical and mental health. It can be used to harass or bully a victim into not cooperating with the case. And the information may not be relevant to the case. And I should say need not be shared. I apologize. The information could be harmful to the case, and also it just feels icky, which is, yes, a technical legal term. So privacy is essentially, if you had to define it, the right prohibiting the intervention into and protection of an individual's information or personhood. And in this regard, right, a victim and a defendant are not different in this sense, in that both are trying to protect a lot of the times their privacy, and infringement on that. It is also the underlying basis for most of our privileges and our confidentiality laws. It's its own enforceable right with its own unique standing. And that means that it's something that if it's in trouble, you can go into court and assert rights for it. Now, we're really lucky in that Wisconsin has two different victim rights laws that specifically provide for standing. But in general, common law standing would also justify a right to privacy. And that is in part because we have federal constitutional rights. And that's if you remember from law school, if you went, if you didn't, well done by you. That was smart. We call that the penumbra. It's just this umbrella of rights to privacy. And then, as I mentioned, we have these two kind of specific rights. So the Wisconsin Constitution 9M, it's subsection B, right to privacy, and there's a right to privacy under Chapter 950. It's 950.04.1. I want to say B2, but I think I'm messing that up. So, so this is not anything to memorize. I have the slide, and the slides are available. But I know I, for one, when I'm writing motions and referencing privacy, I'm always like, what are the penumbra rights again? Like, where does this come from? And what are the main cases? And I'm always trying to like remember them. So I just put them all in one place. So you've got them. So all right, so what laws can we use to protect privacy? And what I would say is that there are essentially four main types of laws that we use in order to protect their privacy. The first are confidentiality laws. So these are laws that make the information itself confidential. So that's something like HIPAA or FERPA. FERPA is the Federal Education Record Protection Act, where essentially an entity is holding information and private records, and they have certain restrictions on whether they'll release those records and under what conditions they'll release those records. The second are laws that are essentially privileges. These are mostly kind of testimonial privileges and evidentiary rules. So you think, doctor-patient privilege, your kind of, 905.045 is kind of that therapist patient privilege kind of thing. So those protect more of communications and interactions that you have with professionals. And those privileges also can have instances where they can be waived. But 905.04 particularly is a pretty strong law that protects privacy. We have the victim rights laws. So Chapter 950, as I mentioned, and the Wisconsin Constitution, otherwise known as Marsy's Law. And then the other thing too is I think sometimes as, a victim rights lawyer, we get really fixated on, Marsy's Law or, Chapter 950. But if you look through statutes, you'll find that there's just kind of miscellaneous statutes that either limit a court or a party's actions or somehow grant a right or ability to the victim, even though they're outside of what is considered the victim rights law. So a good example of that, for example, is 938.3152 is a statute for when a judge is considering to grant a continuance. And it specifically requires the court to consider the victim's position when granting that continuance. And it doesn't say that the victim can control it, but it does say that the court has to consider it and kind of make a record of it. And so I think you'll find that if you kind of look at what the topic is and look at the statutes around it, you might find other things among the statutes that are useful as well. I say that because I think that the best strategy for using laws to protect privacy is really to combine and articulate multiple laws and their intersection to protect the particular issue that you're working on. Victim rights laws are great, and Wisconsin actually has a really long history of being at the forefront of victim rights laws. But the current victim rights laws that we have, particularly Marsy's Law, they're very young. There's very little case law to go to. There's in Marcy's law, there's no legislative guidance whatsoever. There is not any, there's some, but there is not a ton of case law from other states. And you do have to be really careful when you use case law from other states, because even though it feels like Marcy's law has kind of gone state to state and enacted these laws, they're not actually all of the same. Some have different provisions in them, so you want to make sure that it's similar enough for what you're talking about. And of course, those are not only, informative, they're not controlling. They're not worded the best. There are a number of sections that are really unclear. And all of them, both 950 and Marcy's law, consistently remind us that those rights are always going to be trumped by a defendant's due process rights. And so that's a hurdle you always have to overcome. But if you can look at how overall certain laws fit together, then you can bolster those victim rights laws, and you can bolster your argument. You can look for themes in the laws that plain reading of one law requires the plain reading of another law to make it consistent. You can get a sense of what the legislator was trying to do as a public policy argument, or just for consistency. So I think that's the best strategy to go about it. So I would always look at how all of these intersect with each other. And also, I think just in general, it's good, especially because victim rights laws that we have right now are sort of in a state of judicial uncertainty for appeal reasons, that it's really helpful to have options that a court can turn to in order to essentially, pick where to hang their hat. All right. So motions for in-camera review. So when I did the title of it, I was talking about in-camera review, but really what I'm talking about is just discovery in general. And an in-camera review is just, I think, probably the most common motions that we see as victim rights attorneys. So the idea of an in-camera review comes from Pennsylvania v. Ritchie, which is this federal case where an individual was essentially looking for records, which ironically were somewhat in the state's possession, but it's only relevant if you want to have a really long talk about it. In general, an in-camera is a motion requesting that the court review private records of a victim that are not in the possession of the state and do not fall under Brady. And Brady, of course, is the requirement that the district attorney must provide to the victim any evidence which is exculpatory and which is in their possession. And we'll talk about that a little more later. In filing motions for in-camera, the defense has to usually meet a minimum standard for the court to grant the motion. And then just procedurally, what happens is if they meet that standard, the records may be provided for the court. The court alone reviews the record and determines if any of the records should be released. So it could be, like 2 pages of the records. It could be all of the records. It could be none of the records. In that process, if a victim refuses to release the records either to the court or after the court's deemed that they be released, then there is typically a penalty. Most of the case law suggests that the penalty is usually being barred from testifying at trial. You can see why that's really problematic for victims of domestic violence and sexual assault, because there usually aren't a lot of witnesses in those cases. There are some suggestions and discussions in previous cases of other possible, they use the term remedies. I think that's a misleading term, but essentially right now that seems to be the primary situation, is that you're barred from testifying at trial. So what I described just now is essentially exactly the Schiffer-Green process, but we use essentially that same in-camera process for all kinds of requests for school records or pupil records, medical records, since Schiffer-Green tends to focus on mental health records, requests for CPS or juvenile court records. We sometimes call those Herget or bellows motions based on the case law. So if you hear those, financial requests, cell phone requests are something that we're just really seeing a huge amount of. And this is something where I know the Art Project has worked some with defense attorneys, particularly most recently in the Birch case, where the concern for cell phone is not just an issue of tracking, which was kind of originally like the issue with cell phone, but we're talking about like data dumps of your cell phone. So, things that go far beyond anything that would be relevant to a case, your photos, your text messages, like all of the people that are in your contacts, like the websites you visit, all of this stuff that is just far beyond what could reasonably be limited to what the defense would require or what the state would require. So, but essentially these are all discovery requests for what I call non-traditional discovery materials, meaning things you can't get from the state, things that you have to go to the actual victim or alleged victim and get from them, and you find a way to do that. And the most common way to do that is for motions for in-camera review. The other reason that we have these motions for in-camera review and these requests for discovery so often is that the basis for these motions is that the fundamental principle of the law is that everyone should have access to everyone's evidence. So the law really actually disfavors exceptions. So those things I listed before, confidentiality, privileges, the law really kind of frowns on those. If there's going to be an exception like them, there has to really be a good justification for it. There has to be a legal basis, policy basis for why it was created. And so some of the motion for in-camera argument has to do with not just is there a privilege, but is that privilege justified? And in particular, is it justified in relation to the rights that a defendant has in pursuing their case and their due process rights. So anyway, okay, so responding specifically to Schiffer-Green motions, because this is, I think, the area that we've really kind of focused on the most so far. So real quick, if you've never been involved in a Schiffer-Green motion, the standard, and this is me trying to make it as short as possible, is that the defendant must provide a fact-specific, precise showing of the information sought, how it is relevant to their defense, and that there is a reasonable likelihood that records will contain that probative, non-cumulative evidence. I know that's like really bad wording, but you kind of get the idea. Like they have to show that this evidence exists, that they've done some diligence in looking for it, that's relevant to their defense, that there's a likelihood it'll be in the records, that it's probative, and it's non-cumulative, meaning that you can't get the evidence anywhere else. This is essentially the only way that you can make your arguments. There are, again, as we talked about, basis for protecting the Schiffer-Green motion. Really the heart of protecting against Schiffer-Green motions or responding to them is the 90504 privilege. That's your testimonial evidentiary rule protecting confidentiality of communications between doctor and patient. And then connected with that is the confidentiality, your statutes or laws, particularly 14682, which is a Wisconsin state statute that protects confidentiality of records. I would add HIPAA to that as well, but HIPAA actually doesn't really come in quite as often as 14682. There's a really interesting interplay between 90504 and 14682. And by interesting, I mean that they relate to each other, they reference each other, but they are not necessarily consistent with each other all the time. So you want to be careful when you use them in arguing. But essentially what the confidentiality does is restricts or creates a protection for the information to prevent it from being provided to others. And then, of course, there's now victim rights law, and you still have your constitutional right to privacy that you can argue as well. The other aspect of a Schiffer-Green motion is the balancing test, which is, does protecting the privacy outweigh the defendant's constitutional right to due process, put on a full defense or fair trial? And that's something that has really been debated at least 2 times to completion by the Supreme Court at this point, and is running on its 3rd right now. So still going. So how do you practically respond to the motion? Well, obviously you file a motion in response, and it's really important that you get to it at the in-camera request level. I apologize about that. So once they make the request for the in-camera, you want to immediately file a motion arguing that their basis for the in-camera request is invalid. If you're waiting until after the in-camera has been granted, you're really kind of at a deficit, especially if the records have already been provided to the court. At that point, you can file a motion to reconsider. And I think that there's a compelling argument there that the original motion was inadequate because it denied the victim the right to be heard, which is entitled under Marcy's law. And I think that judges have been like fairly responsive to that in terms of letting you talk. I don't know that the outcome has always been what you want. So it's best to get in as soon as possible. And if you're an advocate or another attorney that doesn't handle these cases, or district attorney, that's really like an emphasis that once you get the Schiffer-Green motion, like that's absolutely the time to go ahead and contact a victim rights attorney. And I say that not just so that we have time for filing the motions, but also probably one of the most difficult areas for district attorneys is having that discussion with victims about the Schiffer-Green motion, because you cannot advise them on their legal rights or options. And you you may have a totally different opinion of what you want to have happen. You may want the records released, and by all means, you're allowed to. You run your case the way you want to, not the way the victim wants to. And so you guys may not even be on the same side in terms of what you want to have happen. And so to avoid both that strategic problem and the ethical dilemma, it's smart to have them referred over to a victim rights attorney. So you want to first assert standing, that you have the right to do the response for in camera. Again, we have standing already provided in the statutes in 950-105 and in Marcy's law in subsection 4, and in common law standing, as I mentioned, in terms of privacy rights, and in Wisconsin's general rules of standing. So Wisconsin's rules are pretty straightforward and pretty similar to federal standing laws, where they ask, like, is there essentially an interest or an injury involved to the individual? Is that, injury or interest something that is protected by law or by a judicial standard? And is it something that the court wants to weigh in, essentially? So really, it seems pretty clear that if you're talking about what happens to your private records, like your mental health records, your medical records, you should probably have a say in that. Like, I feel like that's just kind of common sense. Like, you should have the right to say whether, like, something should happen with your records or not. Maybe, doesn't mean necessarily that you control it, but you certainly have the right to be heard on it, things. So one of, I think, the better arguments in Schiffer-Green motions is to argue that the defense doesn't meet the standard. And on that, I would focus on impeachment evidence and evidence being cumulative, because you'll find that most of the case law on Schiffer-Green of it, actually very few Court of Appeals cases or Supreme Court cases turn around and agree or disagree and decide that the motion should have been granted. Most of the time, they find that the evidence would have been cumulative or they didn't meet their standard. And one of the reasons for that is because a lot of time, essentially what they're doing is looking for impeachment evidence. So the argument is they're looking for, what did they tell the doctor that they didn't tell police? Or what did they tell the doctor that's different from their statement? Or did they tell the doctor they're a liar? Things like that. The original idea behind Schiffer-Green was essentially this concept that an individual might have a mental health condition that would affect their ability to distinguish between reality and truth. So somebody that maybe has hallucinations, this is part of schizophrenia or bipolar, something like that. That makes absolute sense and should absolutely be a factor that a jury gets to hear. But what has happened over the years is that things have devolved into, well, they have depression, or the most annoying, frankly, well, they're in treatment now because they were sexually assaulted. Right. And in those instances, what they're not looking for essentially is, can they tell the difference between reality and not reality? They're looking for, are you a liar, essentially, which is for impeachment purposes. And quite often you can find impeachment evidence other places. And usually your basis for the motion is going to be exactly those places you can find impeachment evidence, like, oh, your sister says you're a liar, or you once, lied about this, or something like that. But also there's pretty strong case law that impeachment evidence is not sufficient. And I think that that's a pretty powerful argument. There's even one case that's essentially like, you don't need impeachment evidence, just do a good cross-examination. I would also emphasize the rationale behind privacy laws. So we talked about the balancing test of like really thinking about how this affects defendants' due process rights. But it's also really worth emphasizing how it affects a victim's privacy rights. So there are really, I think, two main rationale behind privacy laws. The first is that there is a general need to protect citizens in getting the treatment that they need. And this has been discussed repeatedly, that the state has public interest in making sure that their citizens receive the correct care, and particularly citizens who have gone through trauma. And if they're not receiving that care because they're afraid to go see a therapist because everything they tell the therapist might show up in court, then we're going to have all of these untreated individuals. And then there's a second public interest, which is that when crimes occur, we want victims to come forward, and we want them to report the crimes, and we want them to follow up on the crimes and come to court and testify, because we have a state interest in crimes being prosecuted. And if a victim knows that by participating in a criminal case, all of this personal information is going to come out and they're going to lose all of this privacy, they're less likely to do so. And so the criminal system is less likely to work effective. One thing about Schiffer-Green motions is that there's yet to really be much discussion of Schiffer-Green with the new rights that have been created under victim rights laws. So right to privacy, right against discovery requests. And I think that's a really big area to kind of like hunker down and focus on. So I kind of skipped over, but we do have one case, State versus Alan S. Johnson. And I put the full name because I do not know why, but there was just like a really large amount of State v. Johnson cases in Schiffer-Green law. I don't know. And I agree it's awkward. I don't know. But State v. Johnson was decided in 2020 by the Court of Appeals, where they did grant victims standing to file responses for an in-camera request and determine that victims had a right to argue for their privacy. That is the case citation. And then after it is the appeal number if you want to go on CCAP, because it is now currently pending in the Supreme Court. But it is pending in the Supreme Court. It has been for quite some time. I don't anticipate having an answer anytime soon. And State v. Johnson is still the law of the land. So that is the one case that we have on Marcy's Law and on standing and Schiffer-Green that you can go to and rely on. So, okay. So sometimes you also want to be really careful in responding to Schiffer-Green motions. You have to make sure your protections are still in place. And this is true with any in-camera. So I mentioned two things repeatedly: privileges and confidentiality laws. But privileges and confidentiality laws are not guaranteed or solid. So with a privilege, you need to determine, was there any waiver? A waiver is when the privilege holder discloses or consents to disclose any significant part of the confidential communication. This to me is like the cruelest thing about the law. I do not understand and probably never will. But disclosure, that waiver, is what's called volitional, meaning the privilege holder does not need to know that they are waiving or that the privilege ever existed. So if you're talking, to your mom about all of this stuff that happened, and you're like, and I told my therapist X, Y, and Z, and then we did this and then that and blah, blah. And then your mom goes and talks to the, defense attorney, and is like, oh, well, she told me X, Y, and Z, blah, blah, blah. You've waived your privilege. And frankly, you waived your privilege talking to mom. She didn't have to go to the defense attorney. That's just what makes it something that comes to light to court. So yeah, it's really very frustrating. And there is absolutely no duty on anyone to inform the privilege holder, first of all, that they have a privilege, and secondly, that there's a chance they could waive it. So for example, if anybody comes to interview them, the defendant or anyone else, or talk to them about the case, they don't have to say, oh, if you tell me what you talked to your therapist about, you're gonna waive your privilege. Can you think? They don't have to do that. And if I was them and wanted that information, I probably wouldn't either. But I think that the general sense that Americans have is, well, of course my conversations with my doctor are protected, and of course my records are protected. And how would that change? And so the idea that can accidentally happen is really just, I think, incredibly frustrating. So because of that potential, you really want to make sure that your actions, when you're involved, when you're working as an advocate, or the district attorney or the victim rights attorney, you want to ask if your actions are causing anything that could be determined as a waiver. And the other aspect to determining whether a waiver has occurred is that it be a significant part of the conversation, and the conversation is not the one you're having about what you talked with your therapist. It's the conversation with your therapist. So there's no bright line. There's no clear delineation of what makes it significant. But essentially the rule is that it's waived if it's a significant part of the matter of the communication, or you determine how important the subject was to the overall confidential communication. So if I'm talking to my therapist, and I'm like, oh my God, traffic was the worst on the way here, and I complained for 20 minutes about traffic, which is not unusual. But I'm like, okay, now let's talk about my actual reasons I see a therapist kind of thing. And then I come home and I tell my husband, all I did was complain about traffic. That would not be considered significant, right? Because it has no bearing on why I'm being treated. But if I'm talking about, something that if I come home and talk to my husband and I'm like, well, this is why we decided to switch medications and this is what we're hoping to achieve, that's going to be considered significant kind of thing, even if it's one sentence. So you have to be really careful there. in confidentiality laws, was there any release? And this is also something that can be really frustrating. Victims are often asked to sign general releases by the police or the DA office as part of the investigation. And I totally get this, especially if it's like a domestic violence that's a substantial battery and you need those medical records in order to get proof of the substantial battery. Or if you're trying to get release for like SANE exams or things like that, what I would suggest is holding off on that, but also I would suggest making sure that the releases are really limited and narrow in scope, because the reality is usually at that point early on, victims are not in a mindset in which they can read and understand their rights in relation to releases. And also, can we be honest and say that HIPAA compliant releases are confusing as all get out anyway? Like, I never really read them fully. I probably shouldn't admit that. But like they're confusing. There's like 1,000 exceptions and like, it's just, bleh. So if a release is signed though, and it's proper, or if a entity that is holding your records receives a subpoena or court order that looks proper to them, they may release the records without notice. The other problem, and this is mostly true in confidentiality law, but it's true in privileges too, is that these are laws that also come with exceptions. And the most problematic common exceptions, things like you've gone missing, we don't know how to find you, we're worried about your safety, and there's a police exception of like, okay, we can get your records to track you down. But the most common one that comes up in terms of criminal cases and victims' privacy is the court order, valid court order. And that's literally the language. There's no definition of what makes a valid court order or how a court order is determined, what information the court relies on, etc. And that is probably the most difficult one to attack. You can try treating it, I think, like a search warrant with a false affidavit, but that is a really hard argument to see to the end. You can try and argue that the judge's basis for it is invalid. That's kind of really, I think, your best bet. But obviously that's a really thin line to walk. So anyway, do not be assured that just because these things exist that your protections are actually in place. Okay, I will make you stop watching Grogu vomit. All right, responding to a subpoena juices tika. I in my life would I dream about having t-shirts made that say a subpoena is not necessarily a court order. Like, stop responding right away. A subpoena is essentially a request for information, again, not provided in or available through traditional means of discovery. I've got the statute there for both, but essentially a subpoena is rarely a court order. They should be contested. They should never be ignored. Do not ignore a subpoena. And we're really talking about our subpoena juices TCAMs because those are subpoenas for actual documents. So how can you deal with a subpoena? Well, there are requirements for subpoenas. They cannot be unreasonable or oppressive. You cannot request material, that is only permitted to be requested by the state. For example, Wisconsin has a statute in which only district attorneys may request cell phone data. So you want to look at the subpoena and read to see what errors there might be. See if the subpoena is requesting material barred by other laws or rules. File a motion to quash or for a protective order. And the best advice that I can give you is when a subpoena juicis tecum goes out to another entity, if it's not you, call that entity immediately and let them know that you're going to challenge the subpoena in court and you're going to file a motion to quash. And then when you file it, make sure you send them a copy. And we get this a lot in school settings because, as I think like Patrick mentioned in one of the chats, schools are just like really bad about FERPA, to be honest. FERPA does have a notice requirement when they get a request for records that they have to at least notify you about whether they're going to release it or not and give you an opportunity to respond as to whether you're going to fight it or not. But more often than not, they don't. They just show up with the records or they send the records. And so calling them to let them know, hey, you have this duty and I'm letting you know that we're contesting it, is a good way to remind them this is the law and your job, and also a really good way to protect the records from getting out before you can do anything to stop it. So, all right. Something that's come up a lot recently is responding to requests for depositions. We've had this a lot. And I think it's really interesting. And I will just tell you, there are certain aspects of Marcy's law that I am just like really fascinated to see litigated. And one of them is this question about the ability to refuse depositions in interviews and other discovery requests, even though that has already existed. So it's really clear in a criminal case that victims have the right to reject depositions. And those are the citations for it. The question is, does victim status and those laws extend into non-criminal proceedings? And we're seeing this most often with family law cases. We're seeing a lot of intersection in that. So the victim is defined as a person against whom an act is committed that would constitute a crime if committed by a competent adult. And the really important language to understand is that it vests at the time of victimization. And I know that that's just a total cringe to defense attorneys and some judges. But the reason for it is not about the defendant's guilt or innocence. The reason is because there are a slew of rights you have as a victim that pertain to how the investigation and the charging decisions and essentially the early criminal proceedings go before the defendant's even involved. And so I think of a victim as a legal terminology, not as essentially a commentary on the defendant's culpability. So if victimization vests at the time that it occurred, and then we have this language in Marcy's law right after that says essentially that the purpose is to protect victims throughout the criminal and juvenile justice system. And then it goes on to say, and to be sure that they're protected by the laws. And then it says in a manner no less vigorous than the defendant. And I think that there's an argument to be made that plain reading of that repetition of protected by the laws and the general term of system and the idea that victim status is so broad, would extend it into non-criminal proceedings. So you don't stop being a victim once you walk into family court, or you don't stop being a victim when you walk into a civil proceeding. And I think that seems to be where most of kind of the persuasive arguments lean. So there's not any case law in Wisconsin, but there is a really great case out of Arizona. And Arizona has been a really early and prolific source of victim rights case law and work. And it's State v. Lee. And essentially what they determined was that where the subject of a proposed deposition is or includes the criminal act, then the victim can refuse. So essentially what you need to do is look at the criminal case and look at the request for the subpoena, and essentially compare what the purpose of the deposition, what the nature of the deposition, and how similar it is to the criminal case, how many of the questions are related, things like that. I think also there's an absolute requirement. I think there's also, let me put that differently. I think there's also an argument to be made that if we absolutely required individuals to attend all depositions in civil proceedings, that it would gut the meaning of the law, not just Marcy's law, but all of the statutes cited above. Because essentially, if I had a criminal case, I think a smart defense attorney would simply file a civil suit, right? Like you just immediately file a civil suit for like defamation or something, right? And then you just, you do your discovery and you get all kinds of stuff and you can do your deposition. So, and I think one of the other things to look at too, one of the things we've noticed is the nature of the case where the deposition request is coming from. If it's a case where, say it's a family case where like the case has been inactive for like 5 years, and then like all of a sudden they're like, oh, we desperately need this deposition. So you kind of want to look at the factors behind it. But I think that there is a lot of arguments to be had in that protecting victims from depositions. And essentially what you're arguing is not that you can't do the deposition, but essentially that you want to file a motion to stay, to seek a protective order, or quash the subpoena for the deposition until the criminal case is concluded. And I would argue concluded through the appellate process, since statements in a deposition could count as new information that would be used potentially to open up an appeal. Okay, so how to protect privacy?
I'm gonna do a time check for you. You have 6 minutes.
Okay, thank you so much. So how to protect privacy by not inadvertently creating discovery problems. And this is unfortunately something we do all the time. So one of the things to be really careful about is to really think about how we generate discovery inadvertently. So when victims are conversing with the DAs, victim witness, other DA staff, remember these are not protected communications if you work with the state. Those would qualify under Brady, especially if they are pertinent to issues of exculpability. So the victim saying, oh, I made this up, or, like changing stories. Sometimes victims want to hand over confidential records to help the investigation. Now that's discovery. Victim packets is an issue that I think really needs explored. Filling out a restitution form that asks for therapy costs is opening the door for a Schiffer Green motion. Victim impact statements that are asked to be done early are one, really don't make any sense because it presupposes that the experience of the criminal case isn't going to have an impact. But again, it's also opening the door to give discoverable evidence to the defense that could lead to requests for in-camera motions. Think also about charging decisions. If you make something an element of the offense, then you make it relevant. So you may want to charge something with an enhancer, such as, a mentally disabled or, like person at risk or something like that. But in order to prove that, you also have to prove, the mental health limitation. And maybe that's okay, but maybe that's not worth doing. Think also about the timing of filing a restraining order because you're creating more statements. Does that really need to be done? And the same thing I would say with transcript statements, reports, or anything for family law cases. But the biggest threats to victims' privacy, don't do that. The biggest threats to victim privacy is the victim's own lack of information. So it's lack of knowledge about their rights and how to enforce them and how they can be lost. It's not knowing that they have a privilege that can be waived. It's signing a release without reading or understanding it. It's agreeing to interviews with defense investigations or others because they think they can't say no. It's misunderstanding confidentiality, assuming the DA is their attorney, a failure to know about or be advised about the ability to talk to and hire their own attorneys. And it's the need for more victim rights attorneys. There just aren't enough and more training. And I am, even though I'm running out of time, going to take a moment to tell you about People v. Cox because it's totally one of my favorite cases in misunderstanding confidentiality. This is a case out of New York. It's several years old. But the defendant was an alcoholic. He murdered 2 people and totally got away with it. Years later, he gets clean. He becomes really active in AA and at a meeting under the belief that AA meetings are confidential, he confesses to the murders. And of course, somebody calls the police and reports him right after the meeting. So it went on for a really long time. It was really controversial, but ultimately the court concluded that there's no confidentiality at AA meetings because it doesn't qualify as a form of treatment or care. And the court forced all of the AA members to testify, and obviously he was convicted. So don't make assumptions, but I've always found that fascinating. Okay, so in the last couple of minutes, some quick practice tips for protecting victims' privacy. And I'm really sorry that I'm missing out on the chat and the Q&A. I'm going to read through all of this and really promise to get back to everybody. First practice tip, most important. As a victim rights attorney, you will very rarely get the victim right out of the gate. So you need to find out everything that's happened before you got involved. What's been signed, what statements have been made, who's been spoken to, and then get your client in the habit of keeping track of the above. Tell them to get a notebook. And if they, it's up to you how you want to practice, but my general sense is, again, they're now represented. If you're representing them, have them get in the habit of referring anyone, calling them to call you instead. Inform them of their rights. I love handouts. I think handouts are the best thing in the world. Give them handouts with their privileges and their rights, how they can be waived or lost without them meaning to. Even if you're not active in the court proceedings, so even if you haven't filed a notice of appearance, make sure you inform the state and defense that you're representing the client, and communication should go to you. Attend interviews and meetings with clients if you can. I know that's hard. Go through their rights as a crime victim and ways they can be asserted. Review any records that are and may be requested. That is incredibly helpful if you're representing them. in a Shipper Green motion. And most of all, file motions, assert all the rights, be creative, connect with other victim rights attorneys for help and brainstorming. Don't give up, like don't give in, and just keep going at it. It's a new kind of Wild West area of law, and nothing's stopping you. So just go for it. So thank you so much for listening. Here's my contact information. Here's how you can refer. And there's also a referral form in the attached materials. I also run a monthly group for victim rights attorneys or I shouldn't say a group, and we meet monthly and we have a listserv. So if you have any interest or you have questions you want to brainstorm, contact us. And that is my time. So again, thank you all so much. And I really hope that you enjoy the conference. So thank you.